crimers, welcome to Break the Case. I'm your host. I'm Jen Coffindaffer. I'm really excited tonight. We have a special show specifically about Becky Hill. Becky Hill was the court clerk that was working during the Alex Murdaugh trial. This really started to blow up really right after his conviction. Again, he was convicted of murdering his wife and his son. He was sentenced to life, two counts or two sentences of life for murdering them. And he's also serving about 65 years on various financial crimes involving defrauding so many people out of money in his capacity as an attorney. But I wanted to dial down tonight on specifically Becky Hill's charges that are against her, combined with what might that mean for Alex Murdaugh's bid to have a new trial. And who better to ask than Philip Dube. Listen, Philip Dube has such a great resume. He's a friend of the program. I know you all have seen him before, but essentially he has served both in the prosecution side and the defense side for decades in Los Angeles. It just doesn't get bigger and better than that. And that's the type of person I really love to have on the show, is people who have walked the walk. So without further ado, Philip, I am going to bring you on. Let's see. Here we go. All this technology. Nope. Add to stage. Let's see. Uh-oh. He's not coming up. Give me 1 second. There he is.
How are you? Happy Friday. It's just spring water, I promise. Okay.
Oh, I'm doing great. Oh, believe me, there's a picture of me floating around with this huge cup of lime water. And of course, you know, the haters want to say, oh, see, she's drinking. Like, oh my gosh, whatever.
No, you should say, tell them I wish.
Yeah, maybe on another situation, but not on that one.
Happy Friday.
Yeah, happy Friday.
Yes.
Well, are you ready to jump right in?
I am ready to rip. Let's roll.
All right, let's roll. So as you know, I know you are really up to speed on this case as well. And I wanted to talk about Becky here really quickly, going over the 4 felony charges she's been charged with and was arrested, released on her own recognizance. Let's talk about, I'm going to go from sort of the least, I think, impactful to the most impactful. So least impactful are the 2 charges concerning essentially using her position or her job for, in one sense, it was financial gain, actually both sense of financial gain, but basically abuse of her position. Tell me what your thoughts are about those 2 charges.
Well, first of all, just a correction note. I think she is on bail. I believe she was granted a full bond of $80,000. I think $50,000 of it was for the perjury, and then $30,000 was for the obstruction counts.
Is that right? I had looked this up, and I saw was it PR maybe in one jurisdiction and not in the other, because she actually had 2 bond hearings. And I bet you I looked at one and you looked at the other. That's why we're a team here tonight.
No, that's okay. I think one of the charges, I think the perjury came out of, what's it called, Richmond County. And then the other 2, I think, were out of Colleton County. But combined, it was 80 grand. And listen, there is no reasonable basis to think that she is not going to come back to court. She's not going to flee. She's sufficiently rooted in the county there, the community. She's not going anywhere, you know. So, but having said that, the lady's in some big trouble. I mean, let's call it what it is, you know. But to be honest with you, I think the most defensible count is the perjury. And by the way, in South Carolina, perjury carries up to 5 years in state prison. It's a felony. And it's serious, but I think it's very defensible on these facts. They have to prove that she knowingly and willfully made a false and misleading statement that was material to the outcome. And if you recall, she was summoned into court. And by the way, she should have taken the fifth, frankly. I don't know how she could not have known that she was going to be the target of some future investigation based on everything that was going to come out of her mouth. But she probably thought at that moment that she was untouchable. Nobody would ever look at her in that light. Nobody would ever think to investigate her. And then here we are. But nonetheless, they have to prove that the lie that she told, and just so it's clear to your viewers, she testified at a January 2024 hearing at a motion for a new trial brought by Harpootlian and Griffin, Alex Murdaugh's defense counsel, based on jury tampering. And he felt that he could make a colorable showing that the elected clerk of court had essentially sort of mingled with or interfaced with the jury and swayed their vote. But if we're honest, the perjury that she is accused of committing was at that hearing when she denied releasing any of the exhibits from the trial to a third party or to the media. And as it turned out, many of the documents that were under seal, including photos, and I don't know if they were autopsy or crime scene photos, were allegedly part of that packet of exhibits that she purportedly released to third parties, okay? Had she have admitted it, let's just give her that. Let's just say, yeah, I did that. I'm not even sure it would have been a crime at that point, because all you really had was a court order sealing it. And at most, I think she could have been held in contempt or sanctioned, certainly fired and brought before the South Carolina Ethics Commission that oversees the courts. But setting all that aside, they have to prove as to perjury that the falsity was material to the outcome. Well, how is the release of exhibits to a third party really relevant to whether or not she mingled with the jury? So I don't really think that the lie itself standing alone is a legal form of perjury. Listen, Jennifer, back me on this. You've testified many times over the years at criminal trials, maybe even civil matters, depositions. We're not always precise in our recollection of facts and details. There's always going to be misrecollections, imprecisions, inaccuracies. But the question is, are they material? If they are not material, it's not a crime. And the reason why is our prisons would be full. Could you imagine if every inaccuracy, every imprecision was criminally prosecuted? We'd all be doing life, frankly. And the law recognizes that you have to kind of cleave out, if you will, the falsities that are truly material to the outcome. Because ultimately that is part of that truth and justice seeking process, is to get to the heart of whatever is being litigated. And the fact that an exhibit got released to a third party is so collateral to that entire proceeding that it would be ridiculous to hold her accountable for an imprecision.
Well, it's so interesting you say this because, and I have a picture up here of Judge Toll. And Judge Toll was the judge that was selected to hear whether there would be a retrial. And this is precisely what you were referring to, is actually the testimony that Becky Hill gave before her. And interestingly enough, even in her decision, Judge Toll said, listen, I don't think Becky Hill is being entirely honest here. But that aside, that does not affect this ruling, just to your point, just to your very point. And also, I find it interesting when I saw the question, I went back and re-looked at what Judge Toll asked. And I think she was pretty general. Did you release anything to the media is what I thought she asked. And I thought it was a simple answer of no. But I actually should have had that video to pull up. And this is so to your point. The first part of this was, how does that affect whether she tampered with the jury, right? It's incongruent. And then secondarily, did she, to your second point, misunderstand the general question asked of her? And is she being charged with these two charges, the perjury and obstruction, also related to the release of these documents because she's Becky Hill.
Oh, of course. That's exactly why. And you got to understand something. She would not be in this posture if it weren't such a high profile media case. It would be one thing if the case wasn't coming with all the pageantry that we see with a lot of the big cases. If it was just some joyriding or forged check type case or a shoplifting, nobody would really care. And it probably wouldn't even warrant these types of inquiries of the jury. But nonetheless, here we are. This is the posture. And I think, in fairness to her, that the perjury count is an overreach. Now, as to the other counts, we can talk, but I think just to throw this one in for good measure, just to see what will stick and to try to, give the lady the shaft, I just don't think that's what our courts are there for. You want to seek justice? Okay, let's get to the meat on the bone and go after her for those crimes, because I truly think that this offense is defensible. My fear for her, if I were defending her, is that the jury might split the baby, say, well, look, we'll let her go on count 3, the perjury, but we're going to stick it to her on counts 1 and 2 that involve the obstruction. And that's not how you dispense court business. And unfortunately, sometimes that's what juries do.
Yeah, you make a great point, but I'm going to play a little bit of devil's advocate here, because I think when you are an elected official, which a clerk of the court is, I think that position pays about, from my research, around $42,000, which is about $20 an hour. And judging from
79. The elected clerk is 79.
Is it 79? See, excellent.
Okay.
Nevertheless, this is not a huge amount of money.
Oh,
at least in the
try to live on that here. Try to live on that, please.
Oh my gosh. Look at this, Philip. And I'm glad you brought up that it was 79. I saw 42. But nevertheless, she had huge responsibility. And for those who don't understand what clerk of the court does, my husband was actually asking me, what do they really do? Oh my gosh, they are the right-hand man or woman to the judge. They run that courtroom. They keep track of exhibits. They actually are the ones in and out with the jury members, and they are making so much of the major decisions right beside that judge. They are the wingman. Anything to add to that?
Yeah, I mean, her position was actually a much higher. She was the elected clerk of the court. Out here in LA, for example, in LA County, the clerk of court gets appointed. They're actually hired and they're appointed from within. It's almost like a promotional opportunity. But in that county out of state, it's elected. So what does that mean? It means that she oversees all the clerks for that Superior Court district. And for whatever reason, they also have them carry cases, if you will, meaning that they are responsible for individual cases that go to trial, and they serve as a judicial assistant for the judge presiding over the case. But otherwise, she was responsible for a staff of clerks assigned to that courthouse, if not to that entire district.
Yeah, big responsibility. And regarding the Murdaugh case, I went over kind of that. It's a huge, like, the clerk of court is who you do not want to upset. They are in charge of so much. And in dealing with these clerks, every time you go to court, they make sure that you're totally lined out with what you're supposed to do, that people are where they're supposed to be. They are the quarterback of that courtroom, in my opinion. And that was certainly her responsibility when it came to Murdaugh.
Oh yeah, and let me tell you, they teach you in law school as a student, and certainly as a new attorney, you never, ever, ever want to upset the court clerk, especially in civil. They can make your life a living hell. There are so many procedural traps in civil litigation with getting things properly filed, getting them filed on time, and any little imperfection in your pleadings, they'll just kick it back. And what do you have to do? You have to go all the way back to the office, amend it, fix it, print it all out, and go back to the courthouse. And then if it happens to be the last day of when your filing is due, you can end up getting kicked out of court for missing the deadline, and you end up getting sued by your client. So rule number 1 is get along with the clerk.
Absolutely. And this is who she clerked for. This was Clifton Newman oversaw that trial. I thought he was amazing. He retired shortly after. What did you think about how he handled his judicial duties over the Murdaugh trial?
First of all, he had textbook demeanor. If you notice, he didn't raise his voice. He never really used any cross words. He didn't have to scream at anybody. He didn't have to have a bailiff escort somebody out. He just had really good command of the courtroom by staying calm and tranquil and composed. And it's so hard to find a judge that can act with that type of equipoise, if you will, because we rarely see it, especially in a high profile case. But he didn't have anything to market. He didn't have anything to sell. He just really wanted to show due process, the criminal justice system live in action, and to see how it is supposed to unfold in real time. And I thought he did a great job. Plus, he was real smart. He was sharp as a tack. And oftentimes the older ones, I'm not going to say they're not as schooled on the law, but they kind of check out and they don't want to have to go in the back and look anything up. But it seemed like just about every issue that had come up was just so commonplace and like, another day at making the sausage for him, that he just knew it. And he could just rattle off his rulings without having to take anything under submission.
One of my favorite moments was when Alex Murdaugh said, "Listen, Judge, I did not do these crimes." And he quipped back and said, "Maybe it was all the painkillers you were on and the opioids that created the man that did the crime." And it was just so quick, right off the top of his head. And I think what all of us were thinking at the time. And Alex even kind of accepted what he said, if you will, in terms of his facial expression, like, yeah, kind of.
Yeah. I mean, he saw right through the man. I mean, listen, he sat through the whole trial. So he heard all the evidence. He heard the key pieces that convicted the man. And to suggest, that he wants him to believe that he's innocent and that therefore he should just cut him loose or give him time served for 2 counts of murder, it was actually laughable. He would have been better off just sitting there saying nothing. But in the perfect Alex Murdaugh tradition, he wanted to have the last word. It's just in his nature.
What did you think of Judge Toll's handling of the issues concerning a retrial?
I like that judge. She was a no-nonsense judge. She had no skin in the game. I think they brought her in on assignment out of retirement, and she was going to just sit there objectively and listen to the evidence, call the balls and strikes as she saw them. And she basically found, A, that Becky Hill was not credible, but that her testimony was inconsequential anyway. She accepted the testimony of that one juror who felt that what Becky Hill did swayed her verdict, but didn't believe her. And in the end, when you're in court on a motion for a new trial and you're relying on testimony, in this case from jurors, just because a juror comes into court and says, this is what happened and this is the effect that it had on me, judge doesn't have to believe it. It's a credibility call. They are not deemed to be telling the truth. They're not deemed to be honest. And the court can just say, look, I'm not going to reach a conclusion that you've lied to this court or that you are being dishonest. But what she was saying is, I have a real hard time believing that one time or maybe 2-time casual interaction that the clerk had with a sitting or deliberating jury swayed your verdict after you've been sitting in that room with 11 other people going over the evidence together for hours. I don't believe in the end that it had any effect on your verdict. So, for example, if there would have been testimony or evidence during that new trial hearing that some of the jurors said, that one juror that felt swayed, she was fixated on what Becky Hill did. She couldn't let it go. She kept bringing it up. She kept trying to get us to vote in favor of not guilty based on what the clerk said. But no, it was just a passing comment in the jury room, if you believe it was even said at all, because some of the jurors said it never happened. Then you decide whether or not that tidbit, if you will, is credible enough to give him a brand new trial. And what she did is said, no, I didn't find her credible. And if you want to appeal, that's fine. And I will punt this and defer to a higher court.
Yeah, Philip, when I look back at this and you so eloquently really set out exactly what happened and why the judge made her decision, I love that you pointed out that point that, listen, the other jurors, they said, anything Becky Hill said did not affect us in the least, or the outcome, or the way we decided this case. Only one stood up, and as you pointed out, the judge didn't really buy it. So here we are, though, faced with, I think, so much noise. Don't get me wrong. I want Becky Hill to be tried. I want her to have a fair trial, but I think if she is adjudicated to be found guilty, I want the book slammed at her. And I want to say why. It's because of her position. And I know under the law, we're all equal. But I just have to say, I hold law enforcement, attorneys, judges, clerk of courts to a higher standard. What do you think of what I just said there?
It's a breach of the public trust if you cannot rely on an elected official, such as the clerk of court, to not invade the province of a sitting jury. One of the most sacrosanct institutions in the United States is the jury system. And to go into that jury room, or to somehow insert yourself into the deliberation process in such a high stakes trial, is a breach of trust. It's a breach of all fiduciary duties owed not just to the courts, to the criminal justice system, but to the public. Because remember, they voted for her. Their voice put her in that seat, gave her that not so handsome salary, but that responsibility to make sure that justice is dispensed fairly. And the last thing that you want to have happen is a 2-count murder conviction to come back on reversed appeal because of misbehavior by the clerk. So at this point, for her obstruction of justice, and for her interference with the administration of court business and court justice, she should stand trial. Now, having said that, do I think she should get 25 years? No. Okay. You can send a message to her with maybe 90 days, 120 days in the hoosegow without having to lock her up for the rest of her life. I think that's silly. The obstruction counts each carry up to 10 years, and the perjury is up to 5 years. And the thought of giving this woman 25 years for this, I think, would be draconian.
Yeah, no, I agree. I would make it a little bit longer. I mean, I'm a little bit harder than you.
That's okay.
2 to 5 years would serve the trick if she's found guilty on all counts. And I'm kind of with you on this perjury. When I looked back at it, I thought it was going to be a little bit more clear cut than it was. But at a much more important issue to me is it had no bearing on what was at issue. And that's kind of the issue. But look, they indicted her, arrested her on it. We're going to see how that ferrets out. What do you think about, I wonder if they're using that as some sort of bargaining chip, because to be found guilty of perjury, a crime of moral turpitude, terrible. Maybe she's going to want to plead to something else and get that off the counts. What do you think?
Well, there's a couple of problems with perjury. Number one, you are forever branded a liar, honestly. And I don't want to be branded a liar or go down in flames behind this type of lie. To say, no, I didn't release a document to a third party. That should cost me my reputation, my character, my future, my livelihood, my elected position. I think that's a little excessive. And a lot of it has to do with the reasons we talked about, where even if she did lie, let's just give her that she willfully and knowingly lied. It just was immaterial to the outcome. Remember, they were there on a motion for a new trial to set aside the jury verdict and get a new trial based on tampering. And to say that because she gave some type of photo or an exhibit to the media or the third party prejudiced the outcome, I don't think that would fly. And I'm not even sure a jury would convict. And another thing, too, is that defense counsel on her behalf can go into court and set aside that particular charge based on the evidence that was presented before the grand jury. If the evidence of materiality was not presented to the grand jury, that's grounds to kick that count pre-trial anyway. So counsel has work ahead of him or her. and there will be work to be done. And you never know, she might get that count dismissed anyway and either go to trial on the 2 remaining counts or settle them. The good news about the other 2 counts, under South Carolina law, they are what we call wobblers. Wobblers means that they can be filed as a misdemeanor or a felony. So if she's willing, let's say, to plead out maybe to 2 counts as misdemeanors and end this, that would be a tremendous victory. But kick the perjury so she doesn't have the felony/lying conviction and go down on 2 misdemeanors, that would be a win.
But I'm going to tell you, this is what I think. There is no way they're going to kick him. And this is why. Because at stake here is Alex Murdaugh. And even though I think any legal mind understands that he should not get a new trial based on what she's done, it doesn't have to do with jury tampering. Now, if they came in and charged her with jury tampering, and they had probable cause and enough to go to trial on that, that's a different conversation. But you can imagine how deeply they looked into those charges, Philip, and they must have come up empty, because I'm not seeing any jury tampering. But I think they are livid about at least the perception socially and what Harpootlian is saying and his band of attorneys, that Alex Murdaugh should get a new trial.
Yeah, one of the reasons why they didn't actually file on her account of jury tampering is because it's only a misdemeanor, if you can believe that, in South Carolina. Jury tampering is only a misdemeanor. And frankly, I think jury tampering is worse than perjury. That's just me, okay? You want to lie under oath, I understand. I don't condone it, and I would never encourage it. But when you start tampering with a jury and start bribing them and telling them how to vote or what they shouldn't rely on when going over the evidence together, that's pretty bad. But that is probably why they didn't file, because it was too minor of an offense under South Carolina law.
But Philip, if they could have charged her with that, which I don't think they had the facts to support that, if they could have charged her with that, then don't we have a serious conversation now? Or because it doesn't meet the federal standard in South Carolina of you not only have to tamper, but the jury has to be influenced, right? You need both. And isn't that what the attorneys for Alex Murdaugh are arguing? Listen, this should be new case law at the federal standard. Talk to us about that.
Yeah, basically, I think all you have to show is just that there was interference, that some outsider interfered with the deliberating process. Now, I haven't read the annotated cases interpreting that federal standard, but on its face, it sounds to me that it could come up short. Just because you are mingling with a jury, that is a form of interference. Even just saying to them, "Hi, good morning. I hope you guys have a great day. Let me know when you want to take a break." Arguably, that is interfering. You shouldn't be saying anything to that jury unless a judge tells you to. The fact that you're even opening your mouth and having a conversation, they might like the pin that you're wearing. They might like your blouse. They might like the way your hair is combed. And that interaction could cause their verdict to be swayed in whatever direction they feel it falls into. So in a way, it's sort of a vague word, if you will, that's in the statute, and it's probably subject to attack on First Amendment grounds. It is vague on its face. So there has to be some material showing that the interference, in my opinion anyway, caused the jury to vote or not to vote a certain way. Otherwise, I don't think it's there. I just don't see it.
Right.
And the other thing is Judge Toll actually said, "I don't find Becky credible." And she basically didn't find the juror credible. So if you don't find both credible, how do you even have tampering? I don't even think you get to the misdemeanor, because I think arguably that finding should be sort of, we call it res judicata, if you will. It's a Latin expression meaning a fact already decided on the criminal case, or a law of the case, if you will, where a judge has already determined that that particular statement was not credible, or that interaction was not credible in how it affected a juror's vote. So if you have that determination, that credibility determination made by a court where it's only a preponderance standard, how is a jury going to find her guilty of tampering beyond a reasonable doubt? I just don't think it's there. And that's why they didn't file it.
Well, so for all of the people in the audience, for all of the people who are in social media and so concerned, remember, this trial was something everybody was glued to. It's no different than the Karen Reed trial, no different than Idaho or Lori Vallow. This was a huge trial that all of us were watching closely. What do you think? What do you want to say? And I think I know what you're going to say to all of those so worried that the justice that was found for Paul and for his wife, Maggie, will be somehow overturned and will be back in the courtroom on this case?
I predict it will be. I do. I predict it will come back unless the South Carolina State Supreme Court gives great deference to Judge Toll's finding that one juror who claims that their verdict was affected by Becky Hill, unless they find that was a substantial enough showing and that the court's credibility call should have been of no moment. But let's just assume the worst. Let's just assume it gets reversed and it gets sent back to the trial court for retrial. He's going to get reconvicted. Do you really think that he's going to walk away on retrial? Remember, it's going to be the same playbook. It's going to be the same evidence. And when the jury hears about that Snapchat video that was on Paul's phone, where they can, hear all the conversation in the background and they can hear Alex Murdaugh back there in the dog kennel, he's going to be reconvicted. So if you want to redo this dog and pony show, let's do it. Because let me tell you, that prosecutor, he'll be ready to go and he will win 2 in a row.
So, Philip, this is what concerns me. The first time around, Alex Murdaugh made the biggest error, I think, in the trial. And we all said it at the time. He took the stand. He thought he could BS his way through, getting examined and cross-examined. And it was a huge nightmare, which all of us saw and witnessed. But he got surprised on that Snapchat video. Yes, it was in discovery, but I think the way they questioned him about it, he just looked terrible. He looked like a dog on a wet linoleum floor trying to figure out how he was going to explain that. Secondarily, that kennel isn't there anymore. And some of the jurors, when I saw them interviewed, said that going to that kennel and seeing the close proximity between Paul and where Alex Murdaugh would have been when he shot him, well, we don't need to get too graphic, but completely blew him away and shot his wife. That proximity of things helped them with that. That dog kennel is gone. So I worry about a retrial because I don't think they'll have him testify. I don't think the snap will be as impactful. And then I worry that.
You cut out. Are you there?
When I go off stage, my goes away because I want you front and center. So I'm going to
go. No problem. No, first of all, there was, I believe, maybe 4 or 5 years ago, a change in the law in South Carolina. The state of the law prior to that was if a defendant testifies at a criminal trial, that testimony cannot be used against him in another criminal proceeding. It cannot. And the reason why is they want criminal defendants to be able to freely make a decision to take the stand and exercise their right or waive their right under the Fifth Amendment privilege against self-incrimination, meaning you don't have to testify, but if you choose to, it'll only be used in that particular case. And I believe before his trial, legislation was passed that repealed that statute. So what does that mean? It means that if Alex Murdaugh gets a new trial and he chooses not to testify, the prosecution can read all of his former testimony from the first trial into evidence at the new trial. And the reason why is the law will deem him to be legally unavailable. If you are legally unavailable and you have given relevant former testimony, that testimony can come into evidence. And what will render him legally unavailable is his claiming the Fifth, When you're exercising a constitutional privilege, you become legally unavailable. And if you have testified before on the issue, it's all coming into evidence. So it is there in transcript form. It is sort of laid in stone for eternity, no matter how many new trials he gets, and no matter how many times he chooses not to testify in the future. It will keep getting read aloud to the jury in open court.
Wow, Philip, I did not know that. That is just great information to know. It makes me feel a little more easy, but I just can't imagine that this is going to earn a retrial, because back to the first thing that you said and that we discussed early on, the crimes that Becky Hill is charged with are not relatable to jury tampering.
Here's the thing. Let me tell you why. I'm not going to use the word concerned or worried, but let me tell you why my gut tells me that the state Supreme Court is going to give him a new trial. Remember, correct me if I'm wrong on this, but he initially appealed his conviction and the denial of his motion for a new trial to the Court of Appeals. And the Court of Appeals affirmed the conviction. That's it. When you appeal to the state Supreme Court, the right to be heard by the state Supreme Court is discretionary. So the state Supreme Court was not obliged to even hear the appeal. I think it would have been different if it were a capital case and he was facing death. Then it would be he would have a right to automatic appeal to the state Supreme Court. So what does that mean? The fact that they have granted sort of review of the Court of Appeals decision affirming the denial of his motion for a new trial and his convictions, it's telling me that they want to revisit this for a reason. And it could be for a couple of reasons. Number one, they might think that the Court of Appeals erred and it should be reversed. Or they could think that maybe both courts, the lower court and the Court of Appeals, were correct, but they want to sort of clarify the record on appeal for future cases so that there is published precedent on it that could aid trial courts in the future should this issue ever come up again. So the bottom line is they're given a wink and a nod that either he's going to get a new trial or that they want to clarify law for future jurists. And we won't know until the matter is fully briefed. And right now, the state, I believe, got a 120-day extension to file their responding brief to Alex Murdaugh's appellate brief to the state Supreme Court. So we're still sort of in the brief drafting stage. It hasn't even gone to oral argument. So we won't even know anything for at least 4 months what the status of that appeal is.
These are such great points and great detail you give us, Philip. That's exactly why I wanted you on to discuss all of this. I also wanted to mention we're joined in chat by Judge Erskine, Carol Erskine. She's just amazing. I really think a lot of her. She's a Massachusetts judge for 20 years, now retired. And
hi, Judge Erskine. Love to meet you someday.
So it's always good to have, and there's so many people in our audience that are attorneys, former FBI agents. It's funny, they DM me because none of them are coming out like me with their real names and everything. They're still in the background hiding. But they're like, hi, I was this is who I really am. I'm like, oh, I'm so glad you're on the platform. But anyway, I just wanted to mention that the audience is really thanking you for all of the detail, all of your legal knowledge on this. So just so I know where we stand here, Philip, you are yay, meaning yes, you think he will receive a new trial.
My gut says he's going to get a do-over. I really do. But I also believe that he will be reconvicted. That's just my take on the evidence. He's painted himself into a corner. There's no way out of this. I think the only way that he would have a shot on appeal, not on appeal, but at retrial, is if whoever the trial judge is excludes all the financial crimes. if you remember, it was sort of a mini trial within the murder trial about all his financial misdeeds and all his exploits and ripping people off, and just hoodwinking people and taking all their wealth and their settlement money and everything else. And before you know it, the jury was sort of taken astray, if you will, to look at all the financial crimes, and were kind of taken away from the underlying homicides. So in a way, it was sort of unfair. I actually felt it was extremely prejudicial. I do.
I definitely see your point, Philip. I do think that he will not get a retrial.
Okay.
But this is what's going to be fun. 4 months from now, when we all come back and circle around, and you could be very right, because when I look at just the trajectory of everything and how everything seems to be going, also he has very good attorneys, and that is true. And then watching how Becky Hill is really being charged strongly, with this perjury and everything else. I think it's more because of her position combined with the notoriety of this case. But could it be because, as you said, a retrial is imminent now because of her action?
I wouldn't even say, well, yes, I do believe. And I wouldn't necessarily call it imminent. I mean, he's cooling his heels anyway on all the federal stuff. So he's not going anywhere anyway. I mean, look, no matter what, his life is over. Okay. He's not going anywhere. Okay. The only real issue is housing. Is he going to be housed in the federal joint? Is he going to go to a South Carolina joint? Where is he really going to go? But no matter what happens, he's not getting out, But like I said earlier, all the state Supreme Court had to do was just affirm the Court of Appeals denial of their motion for a new trial and affirm the convictions for murder. But the fact that they didn't, and they've granted review, it tells me either they are going to reverse the Court of Appeals or they're going to clarify law for future use.
Yeah, excellent point. Excellent point. I think you're right. Philip, I tell you, we got through this quick. That's another reason I love having you on. We don't belabor, we hone in, we fire and shoot, and then it's time to get off. So okay. I really want to thank you for your insights. I hope you come back and join us again. The audience loves you. We love your sense of humor. I did not wear my jail stripes today.
I love it. Okay. We ought to make that our brand. We'll both wear them. Oh, we'll give you pink stripes. We'll give you black stripes, and we'll look like, we're sort of rivaling inmates, I'm
going to go with baby blue stripes, because anybody to think that I am in support of somebody who loves pink, although I swear I will not let the color pink ever be related to Karen Reed. For me, it's the beautiful color pink. So I might wear pink stripes after all.
Absolutely.
All right, Philip, till next time. Thank you again for joining us. And may just
everybody likes, shares, and comments on this broadcast. It was great. And you all can follow me on X. Follow me on X for some other content. Okay.
I love some of it. I just commented, liked one of the ones I saw pop up of you, because you add this flair of levity. And I love that. For some reason, I can't seem to get away with it. I try to put up anything sort of funny, and everybody's like, "Oh, you're so unprofessional as a retired FBI agent." I'm like, I'm a person, and I really have a good sense of humor. So, but I keep it away, but I love to see yours. And yes, definitely follow Philip on X. And I hope you're back many more times, Philip.
Thank you so much. Have a great night and have a great weekend. Till next time.
Thank you.
Bye-bye. And good night, everybody.
Good night, all.